totally right to me. So I'm wondering, you heard the question that I asked Mr. Overing, and I'm wondering if we disagree at all. If I say the thing that Hall and Moore require is that when you have a score that's 70 or below, you do have to give the defendant an opportunity to come in and to talk about adaptive functioning. But having given the defendant the opportunity to talk about adaptive functioning, yes, of course, you can go back to the scores and to the fact that there are a lot of scores on one side, the upper side of 70, that make you think that that evidence of adaptive functioning just cannot possibly carry the day. Is that what you're saying, or are you saying something more than that?
I think I agree with 95% of, or at least with one or two asterisks. And let me say how I think that cashed out here, and then what the constitutional rule is for how you just think about IQ. The issue is that what you were describing before just did not happen here. The only time that the courts grappled.
Okay, so I take that point. Let's presume that I don't care about it for the moment.
Fair enough.
You know, that all I'm trying to do is to figure out the rule, and then we can go back and say whether the court did it or not do it.
So I think that the part where I disagreed with what you said before is just in the sense that a single low score in all circumstances, no matter what, will always preclude a state from being able to focus on IQ. So imagine, for instance, just a case.
No, I don't think it would. The only thing that I think a single low score does is to say, yes, at that point, the defendant does have to have the opportunity to come in with adaptive evidence. And I take Hall and Moore to have, that is their holding.
Right, so I think I take it slightly less categorically than you do, which is just to say, so you imagine a case of 10 85s and 172. The collective error range of those scores, even if you look at the 95% confidence interval, is not going to grace 70 or below. So imagine a situation like that where I think you can structure it where the possibility remains so low.
Okay, so that's like the hypothetical that you gave in your brief, like there are a lot of 90s, and I kind of take that point, right? Because like at some point, there's no clinician in the world who's going to say that just because you have like one outlier score, that there's a possibility, right? If you have like 6 90s and a 72. But if you have something that's more along the lines of here, right? Then I take it that we are in agreement, tell me if I'm not, that at that point, the Hall and Moore ruling is you have to allow the person to come in with adaptive functioning evidence, but of course, may I, Mr. Chief Justice?
Sure.
But of course, you can say this is outweighed by the fact that there's a multitude of scores on one side.
Yeah, I think that there is broad, and if I can just stress that the two key points of agreement is that moving on doesn't mean you're done. It involves circling back to the standard that state law imposes. And I think in turn with that, it's helpful to clarify what I think is now a point of agreement, that the one low score rule reading of Hall and Moore, where prong one is satisfied substantively, so long as you have one low score, is wrong.
Right.
Yeah.
Okay.
Thank you, Counsel. Justice Thomas.